אני פותח את הישיבה החמישית. היועץ המשפטי ממשיך לטיעון.
The Attorney General continues. May it please the court.
על רוב השגותיו וטענותיו של הסנגור,
With regard to most of
בעל
the
פה ובכתב, כבר השבתי
statements of the counsel for the defense,
בישיבות הקודמות.
I have replied already in previous sittings.
במידה שהסנגור מסתמך
Insofar as the counsel for the defense
על דעות מיעוט
relies upon minority opinions and judgments at the Nuremberg Tribunal,
ועל דעתם של אותם מחברים בודדים,
and the opinion of certain writers amongst whom
נירנברג שנויים במחלוקת,
there are divided opinions as to the Nuremberg principles, I can only say the following.
במחיר יקר
It's been a very heavy price
של מיליוני נפשות,
of millions of human beings.
התקיע לעצמו המשפט הבינלאומי דרך
International law has hewn out a path to make a way, although rather late in the day, to set down in writing principles which are not innovations. It must be stated in accordance with Clause 6 that the doctrine of active state removes all power of jurisdiction from the state of Israel. Any act of jurisdiction against Adolf Eichmann would therefore be a deviation from international law. As far as this matter affects international law, a final reply was given at the Nuremberg trials. It was completely rejected. In the judgment of the International Military Tribunal, in the double series volume 1, on page 223, page 223, I quote from the English text.
distinction to hostile acts of soldiers by which the latter do not lose their privilege of being treated as lawful members of armed forces, war crimes are such hostile or other acts of soldiers or other individuals as may be punished by the enemy on capture of the offenders. They include acts contrary to international law, perpetrated in violation of the law of the criminal's own state, such as killing or plunder for satisfying private lust and gain, as well as criminal acts contrary to the laws of war, committed by order and on behalf of the enemy state. To that extent, the notion of war crimes is based on the view that states and their organs are subject to criminal responsibility under international law.
From the point of view of the municipal law of Israel, the defense of act of state can be expressed in clause 19 of the Criminal Code Ordinance of 1936 in both its parts.
This paragraph, justifying criminal act, is this relevant to our discussion and debate, our domestic law? I wish to say that paragraph 19 is not relevant. This is what is said in the law for the punishment of Nazis, and that is why this paragraph was introduced regarding heads of state officials will also be brought to justice and tried for such crimes. For the Nazi punishment law, this was excluded and amounts to a positive inclusion of the paragraph included in the international law, which put responsibility on the shoulders of leaders of state who could have maintained that they fulfilled their duty as demanded by their own country. Maybe the intention was to do away with the restrictions in paragraph 19. There is no such defense as act of state in our law, except according to paragraph 19. This is the paragraph dealing with justification. A man can say, I did what I did in order to fulfill a certain law, this is 19a, or in order to obey a certain order, an instruction I was given to fill. This is 19b. Mr. Hausner, do you suggest that we deal with this question and decide without having any proof regarding the facts? This is an alternative argument, but also for the sake of the preliminary discussion and debate, and presuming that the defense will succeed in proving that all the accused did was only obeying orders, even then this is not a justification and not a defense, and he cannot use this as a defense for his deeds. We shall prove that he overstepped his instructions, that he was even harder and he was even eager to fulfill those orders more than they were intended. Even if the defense will succeed to prove to this court that all Adolf Eichmann did only within the framework of his orders. I wish to add that the leaving out of this paragraph 19 in the Nazi punishment and their collaborators law, and this is in paragraph 8 of the law, it is stated clearly that section 19 of the Criminal Code ordinance shall not apply, and this cannot be brought as a defense by the accused. So what are we asked to decide at this stage of the trial? What I ask the court to decide is that an act of state is not a defense. The defense does not claim that this is a justification, not a justification on the merits of the case. But what the defense claims is that the court has no jurisdiction, and inasmuch as the Israeli law does not accept this defense, and the defense claims that this contradicts with international law. So I believe that we are not to be dragged into a discussion of the Israeli law and the implications of the Criminal Code paragraph. I want to prove that the intention was not to include a clause of justification. I wish to bring to the notice of the court what is the Israeli law and to draw your attention that paragraph 8 is in accordance with the international law. And if we read what has been decided by the American military courts, this is on page 30, artificiality, legalistic nihilism, and incompatibility. He goes on quoting a part on page 39. It is clear that there is a certain artificiality in this defense, because had this defense been accepted by the court, then under a dictatorship like Germany, there could have been only one accused, and that would have been Hitler himself. And since he is not in existence anymore, then all the other culprits and those who committed crimes could say, we did not shed this blood, and we did not see, because he was the man to give orders and we were his soldiers, ordered to obey. He, as head of state, also has immunity, because the sovereign is also immune. I shall not dwell upon this debate, to what extent a head of state is immune or not. International jurists discuss this question and have not come to a conclusion. It is believed that the head of state can be brought to justice, but I am not supposed to argue this point. The man before you is Adolf Eichmann, not Adolf Hitler. If we agree to the theory of act of state as a justification, as a defense, then all those who fulfilled Hitler's orders had a justification for the most terrible crimes, for atrocities, and the conscience of the world will not put up with it. And this is what the American military court says.
Aggressive wars, those who knowingly participate therein are subject to trial and, if convicted, to punishment.
And even if Adolf Eichmann had stood trial in the same country in which the Council for Defense had suggested that he should be tried, in the Federal Republic, there too he would not be able to find any justification or defense along the lines of the argument now put forward here. In one of the later judgments of the Supreme Court of Western Germany, and the court will find it in Neue Juristische Wochenschrift in February 1961, on page 373, the question of the application of clause 73 of the German military law is dealt with. We shall submit this clause to you shortly. Clause 73 lays down that an order is justification, an illegal order cannot be regarded as justification for an illegal act.
In German, and I will render the interpretation when it is given in the Hebrew in court. After citing a Supreme Court case, maybe this should not be cited. But the acts spoken of here are very similar to the acts committed by the accused. I want to prove that this claim cannot be accepted. Therefore, all that has been said by the defense, that the accused is at disprivilege for being brought to an Israeli court, is not true. He is given the proper defense. He will get no better defense even in the country where he asked to be tried and was refused, and left the privilege of trying this man in Israel. In conclusion, once again, as my colleague Mr. Halevi said, the problem is different. It is a problem of international law. And I believe this answer is not full and not to the point that a German court would not have accepted such a defense. I said 2 days ago that as far as an answer to this court is concerned, I can say very simply, there is a law, and you, the judges of the State of Israel, are required to follow the law. I believe that all the decisions I bring, the German decisions, need not be brought before you, but the defense maintained that he will not be able to bring all those German decisions, and I maintain that he cannot bring them even before the court in Germany. And in conclusion, the international society expressed its opinion openly that Adolf Eichmann be brought to trial. And he is here before you to be tried according to a law which is now adopted by all civilized people. His contention that he was brought here against his will does not make any difference at all. I brought before you citations and decisions from judgments showing and proving that all ways by private persons, who are unofficial emissaries of the state, or even if they are official agents of the state, the ways of bringing the man to court is not to be examined by the court, and does not change and does not affect the indictment and the jurisdiction of the court. The court has an accused before him, accused according to the law, and to be tried by a competent court as far as the questions of procedure are concerned. All these requirements have been fulfilled. The principle of territoriality I have dwelt upon already. These rules, from their very nature, must be extraterritorial. And there is no invalidity regarding such laws. And the case of Lotus proves it. Moreover, the privilege and the right to bring to justice Nazi criminals according to the trend of thought is a universal right of all civilized nations. The State of Israel has the privilege to try and sit in judgment upon the man who tried to exterminate the Jewish people. And certainly more than any other state. Regarding the question of extraterritoriality, you can also bring the German criminal code trying crimes against the German people committed by foreigners abroad. I know that, Your Honor, but I was not eager to bring this case because it was made in 1940, and although the law is still in force, I did not wish to compare the law regarding the punishment of Nazis and their collaborators with a law taken by the Nazis themselves, although the law is not changed and is still in force. I shall submit the list to your honors. I have all here the books of law of civilized countries. We collected the codes themselves, and I shall submit them to court, all this heap before me, to prove to your honors that this legislation is not something unusual and is accepted and valid. And regarding the fairness of this trial, I regret to say and repeat what the defense said, although it was dressed up tactfully, that the accused fears the trial will be unfair to him here. Jewish judges, the principle is that the law for the citizen and the foreigner shall be the same in your country. They will do justice, and they will do justice unto Adolf Eichmann as well. And if he fears, maybe his fears are founded, but this fear will exist if he is put to trial before any other tribunal in any country and in any other place. I ask the court to reject the contention by the defense, to decide that the court has jurisdiction to try the accused, and to demand that he replies to the indictment. One more factual question, and this arose after I read the American citations. Was the exchange of letters after June 1960 and not the letter concluding the incident, which I already submitted to court. Is there anything in it about the question of extradition? I think this should be submitted. Another question. Does Israel have an agreement for extradition with Western Germany? No, Your Honors. Thank you. Please, Dr. Sabbatius. Quiet. Here's a good speech. Does Israel have an agreement for extradition with Western Germany? No, Your Honors. Thank you. Please, Dr. Sabatius. Quiet.
It's a good speech. It's a good speech.
Yes, but it has to remain open when Sabatius speaks German.
Where is the speech? Oh, it's there.
In diesem Stadium des Verfahrens geht es nur um die Frage der Zuständigkeit des Gerichts. Mit der Schuld des Angeklagten und der Fairness des Verfahrens haben wir es jetzt nicht zu tun. Meine Ausführungen beziehen sich also nur auf die Frage der Zuständigkeit. Der Herr Generalstaatsanwalt ist dem von mir vorgebrachten Zweifel an der Anwendbarkeit des Gesetzes zur Bestrafung von Nazi und Nazi-Helfern Piraterie, Menschenraub und ähnliche Verbrechen könnten in der ganzen Welt nach dem Weltrechtsprinzip verfolgt werden. Diese Täter seien Feinde der Menschheit und müssten von jedem Staat für die Zukunft unschädlich gemacht werden.
The attorney underlined piracy and slave tradery, where the hand of law will reach and get them wherever they are according to international law. To those who commit such crimes, the enemy of humanity, they must be taken care of so that no more harm can be done.
Das Prinzip müsse auch hier auf den Fall Eichmann angewandt werden.
The Attorney General believes that in the case of Eichmann, this should be the principle, the guiding principle.
Ich halte dem entgegen, dass der Angeklagte keine Gefahr für die Menschheit darstellt. Er ist mit dem Ende des Hitlerregimes ein friedlicher Bürger geworden.
And to this I reply that humanity is not in danger from the accused. With the conclusion of the Hitler regime, he has turned to a peaceful
Er hatte
citizen.
das Unglück, einer unmenschlichen Regierung verpflichtet zu sein. Die Gedankenwelt dieser Regierung hat er überwunden. Er ist befreit von seinem Eid, durch den seine Treuverpflichtung missbraucht wurde.
He was unfortunate and had to take orders from an inhuman regime. He was above the morals of that government and has freed himself from the oath he has taken.
Ich nehme sodann noch Stellung zu der von dem Angeklagten in Argentinien abgegebenen Unterwerfungserklärung, wonach er freiwillig nach Israel kommt.
And now, I wish to speak of the declaration given by the accused in the Argentine regarding his coming to Israel of his own free will.
Die Frage der Zuständigkeit dieses Gerichts für den Angeklagten brauchte nicht weiter geprüft zu werden, wenn der Angeklagte sich tatsächlich freiwillig dem Gericht unterworfen hätte.
There would have been no necessity to add and examine the question of the competence of the court had the prisoner come of his own free will to this court.
Der Herr Generalstaatsanwalt hält die Unterwerfungserklärung für unerheblich. Aber das Gericht könnte ihr Bedeutung beimessen. Daher will ich dazu Stellung nehmen.
According to the Attorney General, the declaration is not relevant, but maybe the court will attach importance to this declaration. Therefore, I have to speak of this declaration.
Prima facie ist anzunehmen, dass diese Erklärung erzwungen ist. Es ist daher Sache des Anklägers nachzuweisen, dass dies nicht der Fall war.
On the face of it, the declaration has to be regarded as obtained by duress. Therefore, the Attorney General must prove that this was not so.
Im Sicherheitsrat der Vereinten Nationen hat keiner der stimmberechtigten Mitgliedstaaten die Ansicht der Freiwilligkeit der Erklärung vertreten.
In the Security Council of the United Nations, nobody expressed, those who had the right of vote, that this declaration was given of a free will.
Freiwilligkeit wäre die Beschwerde Argentiniens ohne Debatte zurückgewiesen worden. Sie wäre wohl kaum auf die Tagesordnung gekommen.
Had the opinion been expressed that the declaration was given of his own free will, there would have been no lengthy discussion about the Argentine complaint. It is difficult to believe that it would have been on the agenda at all.
Ein weiterer Punkt. Zu der Zustimmung des Sicherheitsrats zur Aburteilung des Angeklagten.
And more, regarding the consent of the Security Council to the trying of the accused.
Der Sicherheitsrat hat in der von der Anklage vorgelegten Präambel zum Beschluss vom 23.06.60 die Ansicht geäußert, der Angeklagte solle vor Gericht gestellt werden. Aber das Ziel der Entführung war, den Angeklagten vor ein Gericht in Israel zu stellen. Gerade dies hat der Sicherheitsrat nicht gebilligt.
The Security Council, in the preamble to the decision of the 23rd June 1960, expressed its opinion that the accused should be brought to trial. But the aim of kidnapping was to bring the man to trial in Israel. And not, this is what the Security Council confirmed.
In dieser Präambel ist eine Einschränkung enthalten. Der Angeklagte soll danach vor ein geeignetes Gericht gestellt werden, appropriate court. Damit war das israelische Gericht ausgeschlossen.
In this preamble to the decision, there is a condition, a reservation. It says that the accused be brought before a suitable court, an appropriate court. This does not mean necessarily the Israeli court, and excludes the court in Israel.
Be brought to appropriate justice.
It says shall be brought to appropriate justice, not court. This is the Judge Halevi's remark. Appropriate
Ich habe jetzt jetzt nicht hier. Ich nehme an, dass es wohl stimmen wird dann. Es ergibt sich aber aus dem Zusammenhang, was gemeint ist.
I do not have the text before me. I take it that you are right, but this is really what one understands from the context.
To appropriate justice.
It does say appropriate justice. Discussion regarding the Hebrew translation of appropriate
Der
justice.
Ankläger hat schließlich auf das Fehlen eines völkerrechtlichen Konflikts hingewiesen, sodass die Aburteilung des Angeklagten nicht gehindert sei.
Likewise, the Attorney General pointed out the fact that there is no question of a contradiction and fiction of the law of nations, and therefore the court can try the
Der
accused.
Empfehlung des Sicherheitsrats der Vereinten Nationen haben die Staaten Argentinien und Israel durch gemeinsame Erklärung vom 3.8.60 den entstandenen Konflikt beseitigt.
By recommendation of the Security Council of the United Nations, this incident was closed according to a joint declaration of August 1960 by the Argentine and Israel.
Der Wortlaut dieser Erklärung enthält aber keine Zurücknahme des Vorwurfs, dass mit der Entführung das Völkerrecht verletzt worden sei.
But in this text of the declaration, there is no retreat of the contention that the kidnapping was against the law of nations. This still exists, and the accused can rely on it. The accused can rely on this fact.
Ein Konflikt zwischen der Bundesrepublik Deutschland und dem Lande Israel ist nicht entstanden. Aber die Intervention ist noch möglich. Der Konflikt kann noch in jedem Stadium des Verfahrens entstehen.
There is no friction between the German federal government and the State of Israel. But interference is still possible, and this may still arise at every stage of this process.
אדוני טוען
You claim that
ההצהרה המשותפת בין ארגנטינה
the
וישראל
joint declaration by the Argentine and Israel
אין פירושה
does not mean
שארגנטינה
that
מסכימה לכך
the Argentine consents that the accused remains in the hands of the State of Israel.
Ich verstehe die Erklärung so, dass im diplomatischen Verkehr die laufenden Schwierigkeiten beiseite geschafft werden sollen, ohne diesen Punkt des Völkerrechtsbruchs weiter zu berühren.
I understand that in diplomatic relationships between the two countries, this obstacle will be removed without adding and without continuing to study the legal question of the matter.
Zu dem noch möglichen Konflikt mit der Bundesregierung Deutschland bemerke ich noch, der Angeklagte hat gegen seinen Staat einen Schutzanspruch auf Intervention. Er kann bei Untätigkeit seiner Regierung diese Intervention durch Klage vor dem Verwaltungsgericht fordern, und er wird dies tun.
Regarding the German Federal Republic, I wish to add that the accused has a claim for protection towards his country and for the intervention of his country. If his government takes no action regarding this requested intervention, he may still file a complaint before the administrative court, and this will be done. Is he a German citizen?
Jawohl, ist deutscher Staatsbürger.
Yes, he is a German citizen.
לא אזרח אוסטרי.
He's not an Austrian?
Nein, ist nicht österreichischer Staatsbürger.
No, he is not an Austrian citizen because his father gave up Austrian citizenship
über die gesetzliche Frist hinaus erwachsen.
and he was brought up as a German citizen. He was an adult when his father gave up the Austrian citizenship.
Es zeigt sich also, dass der Konfliktstoff noch nicht endgültig beseitigt ist.
It means that the question of this disagreement is not settled yet.
Zuständigkeitsfragen bleibt aber die Aufklärung, ob die Entführung des Angeklagten aus Argentinien im Auftrag der israelischen Regierung erfolgt ist.
The focus of the jurisdiction of this court still remains the clarification of the question if the kidnapping of the accused from the Argentine was done by orders of the Israeli government.
Der Herr Ministerpräsident des Landes hat seinerzeit im Parlament erklärt, dass die Entführung durch Beamte des Sicherheitsdienstes erfolgt sei.
I wish to correct the defense.
ראש הממשלה של המדינה הזאת
The Prime Minister of the state informed his parliament at the time that the kidnapping of the accused was done by men of the security force of the state. I wish to interrupt. The Prime Minister informed in Parliament that the security powers revealed the place where the accused was found. That and nothing more.
Mir ist diese Erklärung nur bekannt aus den Diskussionen im Sicherheitsrat der UNO. Deswegen ist es möglich, dass die Originalerklärung abweichend ist. Aber das war die Grundauffassung im Sicherheitsrat.
I know the words only from discussions at the United Nations Security Council, so maybe that the texts do not tally, but actually they amount to the same thing.
Dann später im Sicherheitsrat darauf hingewiesen wurde, die Entführer seien Freiwillige gewesen, so liegt darin kein Widerspruch. Auch Freiwillige können die Ausführung eines Staatsauftrags übernehmen. Dies sollen die Zeugen klären und ich bitte das Gericht, die Vernehmung der Zeugen zu gestatten.
If later at the Security Council of the United Nations the things was put to vote and it was pointed out that the kidnappers were volunteers, there is no contradiction. Volunteers can also undertake a state operation. This can be clarified by the witnesses themselves. Therefore, I request the court to permit the hearing of those witnesses. I still do not understand why you attach importance to the fact if he was kidnapped by order of the state or by the initiative of individual persons.
Wenn der Staat selbst den Befehl gibt, eine Handlung auszuführen, die gegen das Völkerrecht ist, dann kann der Staat nicht sich darauf berufen und das Gericht darf einen solchen Akt nicht anerkennen. Das ist meine Ansicht.
And if he was kidnapped by initiative of individuals, does this court have jurisdiction? If the court gives an order to do something which is against international justice, then I believe that the state cannot rely on such an act. I want to know your opinion, the opinion of the defense. Maybe the court will decide otherwise, but I believe
die Unzuständigkeit des Gerichts gegeben ist. Nur im Falle, wo der Staat selbst den Befehl gegeben hat, ist die Rechtslage sehr viel klarer, als wenn es Freiwillige macht.
In my opinion, the result is the same. But if the state itself gave the order, then the legal question is more complicated. Easier. Not complicated, easier. This is correction made by the judge. I conclude. Nothing more to say. There's a break. A break.
אני מבקש שקט באולם.
Please, silence in the hall.
החלטת בית המשפט על
The
הטענות
decision of the
התרומיות של
court
הסנגור
regarding the preliminary contentions will be given on Monday at 9 o'clock. And the court adjourns until Monday at 9 o'clock.